Take just a moment to recess while we change panels. Thank you. We'll start with the Hanneman versus State of Florida case on the criminal docket.
I've known Marcy Lippincott since I've been 12 years old. Her mother...
Never mind. Let me reintroduce the panel, adding Judge Marlene Alva. She's visiting with us today. She's from the 18th Judicial Circuit. And thank y'all for being gracious enough to allow the other lawyers to go forward. In the Hanneman v. State case, sir, you begin.
Good morning.
Good morning, sir.
William J. Schaefer, 6090 Central Boulevard, Orlando, Florida, on behalf of appellant. We're here on a competency of counsel appeal from the denial of the 3.85 motion at the trial court. In order to establish, excuse me, that the defendant or appellant was deprived of effective assistance of counsel, there is the issue of counsel's performance and whether it was deficient, and he was not functioning as a counsel guaranteed by the Sixth Amendment, and two, that the deficient performance prejudiced the defense because counsel's errors were so serious as to deprive the defendant of a fair trial.
Mr. Schaefer, I'm going to interrupt you because I want to be sure that you emphasize certain issues in your brief. Different lawyers approach a case differently. Some lawyers will interview and depose every witness, and some lawyers, as part of their discovery, will not participate in mutual discovery with the state and will depose few witnesses if the documents that they have shows them they don't need to depose the witness. Why isn't this a case of a lawyer with experience selecting the trial strategy that he thinks or she thinks will best support their client's side of the case?
If we're talking about the issue of taking depositions, I would agree with the court that yes, trial counsel, being of that community, knowing those police officers, chose a course to not depose the witnesses because the evidence of inconsistent statements were evident through the police report. So I'm not going to dwell on the failure to take the police officer's deposition.
What then do you think is the most significant oversight that the trial lawyer made?
It all happened at trial. The failure for the trial lawyer to effectively cross-examine the two young women in this case. They were not 5 and 6 years old. They were 13 years old. The failure to call witnesses to impeach the two witnesses with their prior inconsistent statements, and the failure to move to sever these counts one from the other. And
we apply a Strickland standard here. We're looking at what the trial lawyers did.
The standard is that I believe is that this court must accept the trial judge's opinion as to the weight and credibility of the witnesses that testified at the 3.850, but you can't de novo look at counsel's performance, and that's what we're asking to do.
Doesn't Strickland say that we have to give deference to the trial judge evaluation of the lawyer's performance?
Strickland does, yes, sir. I agree with you there. The problem also is that this counsel compounded his failure to adequately cross-examine, adequately impeach the two girls' testimony when in his opening statement he says to the jury, you're going to hear inconsistent statements, that these girls made inconsistent statements. I believe that's important, and look for that to come out. He never produced it.
Wasn't there shown in the trial the inconsistencies in the young lady's testimony?
The inconsistencies, but that's not what, and I'm going to answer that question, but that's not what counsel said in his opening presentation. What he said was they made inconsistent statements to other persons that you will hear about. Now, having said that, yes, counsel said that there were internal inconsistencies as to the girls' statements, and I believe he used external, that is, they disagreed with one and another. But that does not rise to the level of prior inconsistent statements, where a witness at some other time has made a statement that's different than that was made in court. And in these types of cases, I believe, in handling these types of cases, they are so hard to defend against when you have a child, 13 years old or younger, up there saying...
You anticipate my next question. You have a lawyer two lawyers who, they know the community, they've got these young girls. They are aware that there are other witnesses that potentially could be brought into the case on rebuttal to show a pattern of behavior and conduct. So they want to, in my opinion, narrowly focus the case so that they won't have these other witnesses testifying. Isn't that good trial strategy?
No, not in this case. You know why? Because they couldn't get the witnesses in there. The witness that the court's referring to recanted and said that she had never told the police that she had been molested, and that she was not, in fact, molested, so they couldn't bring her in.
My point is that the lawyers considered this and decided on a trial strategy. Let me give you an example. Lawyers have different personalities and different approaches. Let's say a lawyer like Jim Russ might try a case differently from yourself, simply because of strategy. Each of you would be successful in your own way, but your approach to discovery, your approach to handling witnesses, your approach to opening and closing, one of you might be considered jocular, the other professorial, one dull, one energetic, but you are successful. How then can we decide that a lawyer was inept? Is there a benchmark that we look at? You must ask X number of questions, you must depose X number of witnesses?
Firstly, I hope that I'm categorized as the second lawyer in your presentation there, not the first. But having said that, there's still a standard. You're talking about manner versus content.
All right.
He missed the mark on content. His manner, I'm not criticizing his manner. What I am criticizing is the content and his failure to adequately cross-examine. And he gave another reason. I was afraid that if I brought in the police for the inconsistent statements, that the prosecution would then get up and bring out all the consistent statements that were made. You can't do that unless I'm completely missing the mark on the rules of evidence. Just because you impeach a witness, you can't then, the prosecution can't then come up and say, well, didn't you say X, Y, and Z that's just consistent with what you're saying here today, unless there is recent, an allegation of recent fabrication. The counsel was faulty in his reasoning for not bringing out the inconsistent statements and not adequately cross-examining. And it doesn't have anything to do with manner. It has completely to do with content. And an experienced lawyer, as this lawyer and the other lawyer should have been, this is just pretty glaring to me. And if there is a case that there was a failure to adequately represent at the trial level regardless of whether depositions were taken or not, is just glaring. And I think it actually touches on whether or not there was a wrongful
conviction. Does the record reflect that the counsels for the defendant discussed their trial strategy with him and solicited his advice be going forward at certain phases of the case?
Your Honor, it does, and you know what? I find that almost ludicrous, if not disingenuous. That's like me being diagnosed with cancer of the bladder, and then the doctor says, okay, there are these ways that we can handle it. Mr. Schaefer, what do you think is best? Now, I've been a doctor for 30 years, but we're going to tell you what the course of treatment is. You make the selection.
Well, isn't that like a male going to the doctor with prostate cancer? He has options of cryo, seeds, radical surgery, and him making the decision based on his age and family, what options he's going to take?
But I think that's a different type of a decision making than
well, my point is, did they talk to the client, discuss strategy, and after talking with the client, make a decision? Does the record reflect that?
The record reflects that yes, Mr. Brown and Mr. Alls indicated that they discussed trial strategy with their client. I believe that the bottom line is that you discuss with your client whether or not to take the stand, but as far as trial strategy is concerned, I don't trust that after 30 years that someone who is their very first trial, who has not had a law school education, is in a position to direct me how to cross-examine or to prepare or present a case.
Hypothetical, a lawyer has a client, he's charged with this charge. The state has a weak case. They come to the lawyer and say, we will offer you a plea to reduce charge, probation, but your client will be adjudicated guilty. And you take it to your client says, I want to go to trial, even though I may spend 15 years in prison because I didn't do it.
And what is the question, Judge?
Does that affect the trial strategy or how the lawyer would go forward in that case?
No.
Okay.
No. And let me give you an example. Had a client that was it was his second trial for...
You've got 3 minutes left. I just want to...
Okay. Thank you. For possession of cocaine, they offered me 3 years in jail and an adjudication. And he says, I can't do it. God has told me that you can save me by going to trial. And against my advice, we went to trial, and Judge Adams gave him 30 years after he was convicted. So, but it didn't change how I was trying the case, Your Honor.
Thank you, sir. You have 2 minutes and a half remaining.
May it please the Court, my name is Chris Davenport and I represent the state of Florida. The trial court made a finding here that this was strategy, how much to cross-examine a child sexual abuse victim on the witness stand, whether you bring out every single inconsistency or go with, the inconsistencies that were apparent. These girls' stories didn't match very well, and they emphasized that in closing argument. And the jury found them to be credible. I mean, they did their best. They had a strategy. It turned out it didn't work, but they did get them off of 4 counts of sexual battery, so they were effective in some ways. This was purely a strategy decision, how much to cross-examine them, whether to bring in every inconsistent statement. Even the defendant's own experts at the 3850 admitted you have to be careful when you're cross-examining a child victim like this. You don't want to make the jury mad. So they're walking this fine line. I think this is pure second guessing here. He would have done it differently. He would have brought in more inconsistencies. That doesn't make this counsel's performance deficient. So we would ask the court to affirm. unless the court has questions.
If your position is that it was strategy to handle the cross of the children gingerly, wouldn't another way to accomplish the end of discrediting them to have been called the police officers as witnesses who could have testified to the prior inconsistent statements, allowing you to still handle the children in a rather gingerly manner?
They could have called the officers, but that would also open the door to the prosecutor being able to cross-examine and lead the police officers. This was a tough prosecutor. They didn't want to risk that. They were really careful to not open the door to other allegations that were out there. And, you know, the children had said consistent things in their interviews with the officers, too. They wanted all the story to be coming from these kids that they thought were not credible witnesses, rather than kind of repeating what they had said through the eyes of a credible officer. So they were careful. It was a strategy decision. Another attorney might have done it differently. They might have called these police officers, taken the chance, and let the prosecutor cross-examine them. These guys decided that would not be a good idea. Is that reasonable? I think it's reasonable.
But wouldn't the scope of the prosecutor's cross have been limited by the scope of the direct?
Yes. But it's awfully easy to open the door to other things. I mean, they have to be careful, and they wanted to be extra careful and not take that chance. Given the fact that they picked jurors that were receptive to a defense of these kids' stories didn't match, they thought that things were going well. They thought the defendant was a credible witness. They thought that the kids' stories didn't match. They had a good closing argument. I mean, they emphasized the inconsistencies, and that could be enough, and they took that chance. A reasonable strategy. Again, someone else might have done it differently. The question is, was this a reasonable strategy, deferring to the strategy that was investigated and considered by the defendant and his experienced lawyers? This was reasonable.
Well, I guess we would have to assume that the strategy was the one laid out in the opening statement by defense counsel, which was to basically elicit prior inconsistent statements to discredit the victims. If that wasn't done in an effective manner, how would that be following on the strategy that apparently was
Because counsel testified at this evidentiary hearing that it wasn't just about prior inconsistent statements. It was the inconsistencies between the two victims. I mean, one victim said that she witnessed the abuse of the other victim. The other victim said, no, that never happened. They had testimony about some system of blinking and coughing to distract the defendant when he was molesting one of them. I mean, there were inconsistencies within the trial. He talked about in opening statement, these kids are not consistent. They've told people different things. And on cross-examination, they went into that a little bit. They said, have you told somebody else that this happened more than once with the oral sex? No, I think it only happened the one time. I mean, they did bring out some inconsistencies on cross-examination. So it's not like they presented a defense in opening and then abandoned it completely and went with something different during the trial. That's not what happened. Again, you know, hindsight, he would have done it differently. He would have done more. But they were also walking that fine line with the jurors. And they needed to be careful. They didn't want to open the door to the prosecutor, and they wanted to be careful with the jurors. And I think that's reasonable in this type of case. If the court has no other questions, we would ask you to affirm. Thank you.
Briefly, Judge Alba pointed out something that's absolutely positively true, and I quote in part what Mr. Brown said at the beginning of his opening statement was that there will be inconsistent statements, that they told one story one time and told another story another time. It can't be any clearer that he's referring to, we're going to bring in witnesses to show that there were inconsistent statements by these two girls. He did not do it. This almost myth that in effectively cross-examining these girls, you're going to open the door to bring in other evidence is just that. It is baseless because, quite simply, you cannot again bolster the testimony once you impeach by bringing in consistent statements, number one. Number two, the evidence of yet another allegation had been recanted and denied, and the prosecutor could not have brought that witness in to impeach her own witness. It is a failed trial strategy that was not followed through with. And also, I want the court to take a good look at the failure to make a motion to sever these girls one from another. I cannot, for the life of me, understand why in the world a motion to sever wasn't made, because it should have been granted.
Well, the reason was they said they didn't want this case to be tried twice in the state, getting a better understanding of the defense and strengthening the case. But should we look at the fact that they were 80% successful in this case?
No, you know what? They were 80% successful. Even a blind squirrel gets an acorn every now and again.
Is that the standard we should use, a blind squirrel?
Sir?
Is that the standard we should use, a blind squirrel? Could have won this case or lost this case?
I think that they just lucked out because she gets on the stand and says, oh, I was only molested one time as opposed to 5 times. Had it not been for her doing that, he would have been convicted on all counts. And besides, how many life sentences can you get? Life is life.
Thank you, sir.
Thank you, sir.